is Section 4, the principle of separation of power in Nigeria. Now, I've said it before now that we practice what we call presidential system of government, under which we have the three arms of governance, the executive, the legislative, and judiciary. I want to make it clear. All these arms are very, very important. They are all in coordinate operations. None of them can do without the other. But unfortunately, in our own system, you see a lot of interest in the executive because they want to execute actions. Most politicians are involved in the executive arm of government, where monies are expended, where monies are, But looking at them all, these arms all ought to work together for proper running of the system or democracy. So there ought to be separation of powers, even though they are interwoven. The term separation of powers is an influential concept in modern democracies. It denotes the practice of dividing the powers of government among different branches thereof. The doctrine of separation of power is geared towards efficiency, but also more importantly, towards guiding against abuse of authority. Hence, it is a liberty-sensitive concept. For instance, if you just allow the politician and the executive to decide who governs, for instance, let me give us an example, the election that is coming out soon in Anambra State sometime in November. Everybody wants to be governor. You see the intrigues going on here and there. At the end of the day, these candidates, many candidates will emerge, but it will only be one person that will become a governor. So when these actions are completed, you see people rushing to court to get injunction, judgments, court pronouncements on issues. We've seen a case where a governor was removed by court order or by court judgment. So which means that all these acts, they work together, they work separately to make sure there's proper governance. So a government of separated power assign different political and legal duties to legislative, executive, and judicial department. This means that while the legislature has the power to make laws, the executive branch has the authority to administer and enforce the law. So then, judicial division, on the other hand, tries cases brought before the court and interprets the law. It is this latter function that constitutes the court power on judicial training. In the 1999 Constitution, the Constitution that we are practicing, is specified these functions. So when you take time to go to Section 4 and 5 of the Constitution, it deals with the legislative and the executive power respectively. Section 6 is concerned with judicial powers. So it must be noted that in Nigeria that the three branches are not completely sealed off from each other. I said it before. They interwoven. There is interconnectivity. They interrelate to make sure that proper things are done. So when you go to the Nigerian Constitution, you understand the operations of these three arms of governance. So here we practice the presidential power. The president has the power to execute, issue orders, do such things as that. But you find out that there are situations where orders may be issued by the president. The court will give an order to stop it based on the provisions of the law. So they interwork dependently on order to achieve proper governance. So separation of power is geared towards efficiency and guiding against abuse of authority, absolute abuse. You may see, if you allow the governor to exercise all the powers, you will be the judge, you will be the executive, you will be everything. So at the end of the day, the whole system will collapse. Now, the review of legislative and executive action by judiciary. The power of judicial review of legislative acts drive principally from 1999 Constitution that provides, same as otherwise provided by the Constitution, the exercise of legislative powers by the National Assembly or by the House of Assembly shall be subject to the judicial of the courts of law of judicial tribunals established by law, and accordingly the National Assembly or a House of Assembly shall not enact any law that alters the judicial of the courts of law and of a judicial tribunal established by law. So these are all checks and balances. If you allow the legislator to just issue out law, they will do man being selfish. They will always do a law or enact a law that will always take care of their own interest. So when there are provisions that contains these excesses, gives checks and balances, that's what this the judiciary arm ought to be doing, so that there will be order in the society. The Constitution further provides that if any law is inconsistent with the provision of the Constitution shall prevail, and the other law shall, to the extent of inconsistency, be void. So that is it. So we are going to look at there are remedies available under judiciary review. What are remedies? Remedies are, a kind of palliative to wrong being done to a person. So there are remedies available. One of them is quashing order, or the other we call certiorari. For instance, the governor might give an order. Somebody might head to court. And once there is a pronouncement, quashing such order, it stands. So those orders, those remedies are available. There are prohibition, there are mandamus, that's writ of mandate. There are injunction and declaration and damages. So we are going to look at these remedies one after the other, so that the judicial review procedure involves two stages. The first is bringing an application without notice to the other side, an ex parte motion. I've said it before now, the one that happened recently, the issue of the removal of the PDP chairman. So when an ex parte motion order is given, it comes as a result of urgency of a particular matter. Probably, if not given, a greater damage will occur. So such orders are sought from the court without the other party knowing about it. There's in the principle of law, there's a principle that is called fair hearing. You cannot bring a matter to court and the judge will sit on that court without hearing from the other party. So that principle of hearing from the second party may not be sought in ex parte motion because of its urgency nature. So you seek the leave of court to bring an application for judicial review. At this stage, among the other things, the court will consider whether the motion raises any question of infringement of a public right, or whether the party seeking the leave has sufficient interest in the matter to invoke the judicial of the court. Next one. It is only on a successful application for leave that the application can proceed to the second stage. At this point, the judicial review application will be filed on notice to the other side and served on them. If the only sought is an order of prohibition of certain rule, and the judge so directs, the grant of leave will operate as a stay of proceedings to which the application relates until determination of application and until the judge otherwise orders. In relation of the view of the legislative enactment, any person claiming to be interested under an enactment can apply for originating summons for the determination of any question of construction and rising under the enactment and for the declaration of the right of the person. So in summary, judiciary is now working in conformity with basic doctrine of separation of power. If we have a vibrant judiciary, there is a tendency that democracy will be deepened because organs in the three arms of government, executive, judiciary, and legislators will know their bounds, they have check